We're going to get a little perspective on both of these issues now. Lucas Vebber, Deputy Counsel at the Wisconsin Institute for Law and Liberty. These folks have been busy this week, but they always are. And Lucas joins us now on the Dan O'Donnell Show. Good afternoon, sir. How are you?
Hey, doing great. Good afternoon. Thanks for having me.
Absolutely. You have been busy. Where do we begin? Why don't we start with this do-over case? The Wisconsin Elections Commission, once again, is doubling down on its stance that the state law does not allow voters to cast do-over ballots, according to the Center Square. And I know the guy who works over there, big fella, has a show on in the morning. Tell me a little bit about what does this ultimately mean, I guess, for the election ahead, and does it impact the primary election just days away?
Yeah, so what happened here is a couple of voters from Dane County filed a lawsuit challenging some guidance from the Wisconsin Election Commission, which was telling clerks exactly what state law says, which is once you cast an absentee ballot, you don't get to change your mind and cast another one. It's pretty common sense stuff. It tracks the exact language of the statute. All WEC did here was basically just reiterate what the statute says. But they brought this lawsuit because they wanted a do-over because they had voted for one candidate, Sarah Rodriguez, who had dropped out of the race, and they now want to vote for a different candidate. And they brought this action in Dane County Circuit Court. They sought what was called a temporary restraining order, like immediate relief from the court. The court held a hearing on it yesterday, very quick hearing, and heard arguments, and then today issued a written decision denying the temporary injunction. So that means you don't get a do-over vote. Once you cast your vote, once you hand your ballot over to the clerk or you put it in the mail to the clerk, once the clerk has it, you don't get it back to just change your mind. Now, if you ever have your ballot at home and you mismark something or you spill coffee on it or you rip it or something, you can bring that ballot back to your clerk and get a new one. But once you actually vote your ballot, you don't get a do-over on what just because you've changed your mind or you want to vote for a different candidate.
Right. Yeah, no, I mean, it makes sense. I am a little bit floored that a liberal Dane County court said, well, no, I'm sorry, you can't do that, when a liberal had asked for a do-over, if you will. This is, though, a matter of basic law. Even the Dane County court system has to understand that, right?
Yeah, I mean, this is just a simple statutory interpretation question. And the judge here listened to all the arguments, and he just said, listen, the statute unambiguously says you can't do the thing you're trying to do here, and just apply the law as written. And that's exactly what, we want judges to do. That's what judges take an oath to do in our state. And so just a good decision, a common sense decision, and we certainly agree with it today.
I have, though, Lucas, seen a lot of traffic online from some folks I respect, people who have worked, at election halls, in election offices, and in ballot counting and all of that sort of thing. And one of the things they bring up is we have such a long absentee process that there are times, again, like this, and I'm sure there are a number of voters that voted for a Sarah Rodriguez or a David Crowley, I think, which is an even better example. The guy drops out, and then all of a sudden he's back in, and you never know when he's going to drop out again. I know it's all complicated, and it would probably create chaos, but is this problematic in your eyes at all because of the very long absentee system that we have, and the concern that you're not going to get the real vote that you want?
Yeah, I mean, I think that's a strong public policy argument against allowing, this month and a half of early voting. I think this is exactly why it played out. This is exactly why people who oppose that have argued against it, right? Because as a matter of policy, things can change in a month and a half. You might change who you're going to vote for. I certainly understand the need for absentee voting if you're going to be out of town, but the earlier you vote, the more likely you are to want to change your mind, and that certainly played out here. But state law doesn't allow you to just cast another vote because you've changed your mind. And the logistical nightmare of 90,000 people deciding to change their vote for all these clerks who have to go fish them out and then print a new ballot and do all that is just astronomical. And we're already asking a lot of our election clerks in the state, and I think that it's a resource issue and it's an election security issue above all else, because the more ballots you have out there, the more likely one of those ballots is going to be accidentally counted or something's going to happen with it, right? They're supposed to destroy these ballots if they issue a new one, but you just never know. So I think there are strong reasons against it, and in this case was a good example of why state law doesn't allow you to do that.
Yeah, agreed. I mean, I think it's very problematic. I understand the concern, but that said, you have to have some kind of a reasonable system in place. You would have chaos otherwise, I think. Let me ask you this. Lucas Vebber joining us, Deputy Counsel at the Wisconsin Institute for Law and Liberty, talking about a couple of big legal issues today, and we always appreciate the expertise of the good folks over at Will. Are there any other election integrity issues? I ask this kind of in an open-ended way, but are there some election integrity issues that you at Will are very concerned about as we move into the primary, I guess, but more so into the general election?
Yeah, I mean, I think there are a lot of things that the state could be doing to clean up the voter registration list that they're simply not doing. Taking a look at non-citizens who are registered to vote, for example, is a really easy way that they could do this, but so far the state has just refused to do anything on it. My colleagues have put out a report on that recently. But I think there's a lot that Wisconsin can do to, very easily clean up our list that they should be doing, and we're just not doing. We'd certainly like to see them do that. The U.S. Department of Justice has been investigating Wisconsin and has requested access to our voting list. That's been in litigation. It just seems like our state is almost going out of its way not to do very basic things that it could do to help protect the vote.
Yeah, again, I think that must show voters that this administration, the Evers administration, isn't all that concerned about election integrity. And maybe that's duh. That's not a revelation. That's been the case for a long time. But I mean, they refuse to turn over to the Justice Department, for instance, these, the voter roll information so that the Justice Department can check. Indeed, if non-citizens, foreign nationals, are A, on our voter rolls, and B, if they're voting in our elections. And they will tell you, Lucas, well, we're not going to do that. It's a privacy issue, and this stuff never happens anyway. These people, they always talk about election integrity, but there are no real non-citizens on the voter rolls, and non-citizens don't vote in our election. I would immediately point them to New Jersey, where we just recently found out that 6,600 non-citizens were on that state's voter rolls. 400 of them, at least, voted in the 2023-24 election. Does New Jersey communicate anything to these dunderheads in Wisconsin that it is time to open the books?
Yeah, I mean, I think it's a perfect example of why it's ridiculous that Wisconsin is going either way to be obstinate on this. It's a common sense issue that I think every voter agrees with. We just need to make sure that the people who are voting are lawful voters. It's not a privacy issue. I mean, if you've registered to vote, you're on a public list and you know it. So, I mean, I just think it's a huge issue. It's an election security issue, and it's something that Wisconsin could very easily fix. All it takes is somebody willing to do so. So.
Indeed. Well, let's shift focus a little bit, and I was just curious to get your thoughts on the appeals court today. It's one battle after another. It's been that way for the last 15 years for the extremely successful Act 10 that really did, and obviously it curtailed the outsized power of the public labor unions in this state. We all know how much public labor money was involved in trying to stop this thing, and some of us are old enough to remember the chaos at the Capitol that the leftists caused in 2011. But I mean, this Act 10 has stood up to court challenge after court challenge. It did again in the appeals court. Are you concerned, however, that this liberal Supreme Court, that where your justices, many of your justices have benefited immensely by the public sector labor unions, that all of these challenges before that survived, Act 10 surviving, that's about to end?
I think, again, just like in the Dane County case we just talked about, this is just another rule of law case. And what they are challenging here is it's a very high bar for the challenge they're making, okay? What they brought was called an equal protection challenge under the Wisconsin Constitution. And what the court does is it looks for a rational basis for the law. So the law has to be rationally related to a legitimate government interest. What the Dane County Circuit Court said was that the way the legislature crafted the groups of public safety employees was irrational and therefore struck it down as unconstitutional. The Court of Appeals today correctly overturned that and said, no, the legislature gets to draw these lines. It doesn't have to be perfect. The legislature gets to make these decisions. Elected lawmakers do. Judges don't get to decide where that line is drawn. That's for lawmakers, and that's what rational basis review stands for. And it's not impossible to win a rational basis review case. We've certainly done it, but it's a very high bar to meet, and the plaintiffs here just didn't do it. And that's why this matters. The Court of Appeals decision today was an excellent decision. I was in line with all of the many cases that have been brought challenging Act 10 before. Our own Supreme Court took the unequal protection challenge up previously. It was a little bit different. In the past, they challenged whether the public safety and non-public safety category violated the Constitution. In this one, the court found that it was which categories counted as public safety, I think is what the decision was all about. So, but it's a really good common sense rule of law decision from the Court of Appeals today. I expect it will be appealed, and it's up to the Supreme Court if they want to take that appeal. But, we'll continue to make these arguments in defense of Act 10 because this law has benefited our client, who's a school teacher in Kenosha, and it's benefited all of us as Wisconsinites for a decade plus now.
Knock me over with a feather that an irrational liberal justice in Dane County found Act 10 irrational. Wow, that threw me for a loop. I was very surprised about that. Final question for you, when does all of this get settled? Either way, when can we know that this is Act 10 is going to continue on, and it looks like it very well may, or this Wisconsin Supreme Court, led by leftists, is going to nuke it?
Yeah, so if they file a petition for review, which is to get to the Supreme Court, you basically have to ask the Supreme Court's permission. So that'll be the next step if the plaintiffs want to do that. That could take, a month or two for the court to brief that out and look at it. Sometime this fall, they'll make a decision on whether to take the case, then they'll order briefing on it. There'll be oral argument probably early next year. And a decision probably next summer would be my best guess on timing.
Very good. As always, we turn to our experts. I mean the real experts, not the Fauci-style experts, but the real legal experts over at the Wisconsin Institute for Law and Liberty. Lucas, as always, a pleasure, and thank you so much for your expertise today.
Hey, thank you for having me on. Have a great afternoon, everyone.